In a historic ruling, the Supreme Court found that former presidents have broad immunity from criminal prosecution. The decision in the case of former President Donald Trump is an additional delay in his prosecution on charges he interfered with the outcome of the 2020 election. And because it's going to require more work done by the lower courts, it makes it quite unlikely that any trial for the former president could take place before the November election. The decision found that official acts have some sort of immunity, while unofficial acts have no immunity. In practical terms, that means some of the core functions of being president, like for instance, vetoing legislation, could never be the subject of prosecution. Other acts, including Trump's discussions with former Vice President Mike Pence on January 6th and leading up to January 6th, are presumed to be immune from prosecution, but prosecutors will have a chance to present evidence to rebut that presumption. That work will all take place in the trial court, where U.S. District Judge Tanya Chutkan, who would preside over the trial, will have to sort out what is left of Special Counsel Jack Smith's indictment. Among the things she will be looking at is whether the scheme to have fake electors in states Biden won insists that actually Trump won the election, whether that effort counts as an official act or as an unofficial act. And if it's the latter, presumably a prosecution could proceed on those grounds. In a scathing dissent, a summary of which she read in the courtroom, Justice Sonia Sotomayor wrote that the decision makes a mockery of the claim that no man is above the law. She said that the Supreme Court majority was essentially elevating presidents to the status of a king in the decision from the court. The court's ruling was 6-3, all from the conservative justices on the court. And 5 of those votes came from the 3 justices who were appointed by Donald Trump to the Supreme Court, as well as 2 others who rejected calls to step aside from the case because of questions about their impartiality. Among those was Justice Clarence Thomas, who wrote a separate opinion in which he questioned the validity of Jack Smith's appointment as special counsel. Lower courts generally are obligated to follow what the Supreme Court decides. In the event Trump is unhappy with whatever decisions Judge Chutkan makes, he can again appeal. Again, there is very little prospect that any of this could happen before the election. And if Trump is elected, there's a real possibility he could then direct the Justice Department to dismiss the case against him. If he is not elected in November, then there's a good chance that the case would continue, although again, the timing now is very much unclear.